We will hear argument this morning in case 2512.
Grievances we could go into with this system. I think we could be here for hours.
National Collegiate Athletic Association.
I think we have some proof, even a few years into NIL now, that people care about the logo.
There are too many people in power who have no desire to give up that power.
The NCAA's ever-shifting decisions, not stable decisions.
Does the concept of amateurism in college athletics even matter anymore?
They've capped it again without any sort of collective bargaining.
We'll finish with our unilateral decision.
Welcome into another episode of Unilateral Decisions. We are so excited to be back. We are remote once again, but joined in the presence of a very special guest here with us today, Olivia Nuss, a sports law attorney specializing in NIL, currently an assistant attorney general in one of the epicenters of college NIL, the state of Louisiana. And Olivia has always been on the leading edge of NIL in various positions and has been a huge part of collegiate NIL from the very beginning. Olivia, thank you so much for joining us. We're very excited to talk to you today.
Mike, thanks so much for having me.
All right, Olivia, we're going to jump right in. What is this role? The Assistant Attorney General for NIL, sports law in Louisiana. What does that entail, and why was it of interest to you?
Yeah, so this has been a really interesting transition for me personally. Prior to this role, I was head of legal and business affairs at Student Athlete NIL, which was essentially the leading consulting agency for NIL collectives. So what that means is we would essentially step in with independently run collectives, maybe propped up by a booster donor, who didn't understand NCAA regulations quite as well. They didn't really understand how to engage in a compliant manner with student athletes regarding third-party NIL deals, and we would take over operations. We would do everything from the legal contracting piece all the way through to experiential marketing with the student athlete, ensuring that the student athlete shows up and does what they're supposed to do as far as deliverables, and ultimately focused on the marketing aspects. So now, having worked with 52 different institutions across the country and have done millions in NIL deals at those 52 institutions with their student athletes, I'm really, really grateful that our Attorney General, Liz Murrill, actually recognizes the need in this industry and sought out expertise in order to kind of bring that perspective into our state legislation. So when I was brought on back in January or February, the conversation was we've had about a year of an NIL task force that was set up by Representative Young. The Board of Regents was present on that task force along with third-party stakeholders like athletic directors, high school and college coaches, some third-party interest, and some attorneys. They all sat on an NIL task force for about a year before the phone call was made to me, and they said, what are the recommendations that we can come up with for the legislature to improve on some of these issues that are trends in NIL? And one of the main things that they came up with was there are no guardrails around high school athletics. There are no regulations, right? We have regulations in our law at a college level, but no one said anything about high school, and we all know it exists. And then B is, what do we do about the NIL agents as a category of agents that has emerged over the past couple of years? And how do we create an infrastructure similar to what is contemplated at a players association level with their registered agents and what is currently in place in law with the federal statute and the FTC? So that's kind of where I stepped in. I made the transition from private corporate enterprise to government employee, and I dug in on legal research and writing on this topic and all of the recommendations that were given. And so in a very short time period, we put together legislation that we feel is the best first step at regulating athlete agents in the state. And then I did a little bit of advising on the expansion of the regulations to high school athletics and what that really looks like in practice. And so right now, what I'm doing for the state is overseeing athlete agent regulation and some of those initiatives that are continuing to evolve around college athletics.
Awesome. Thank you for the intro. It helps all of us understand. And obviously you've got your fingers in a lot when it comes to what's going on in the NIL world. And as you mentioned, Louisiana really kind of taking one of those first steps. Help us understand, help our listeners understand, why is this necessary? Why is an athlete agent representation registration process necessary? What are you seeing in the world that says we absolutely have to step in and, take a role here to allow for these athletes to be protected or whatever it may be? What are the things that led to that just being an absolute necessity in our current environment?
So there were a couple of scholarly articles that we started when we started researching this project that referenced the shortfalls of the Uniform Athlete Agent Act, which was a uniform law put together by the Uniform Law Commission, and SPARTA, which is the Sports Agent Responsibility and Trust Act. And there were several conversations at a scholarly level about how America should reform the sports agent laws to conform with the true agency principles that we are seeing day to day. And so one of the core issues is that when the NIL era began, athlete agents had virtually no regulatory oversight, despite representing student athletes in sometimes multi-million-dollar deals, right? Now, I do want to just give a caveat that the multi-million-dollar deals are your top 1%, but you still have unregistered agents who call themselves agents without any authority, be giving student athletes bad advice, even on an NIL deal that's worth $500. So whatever the worth is, it's a lack of regulation that then causes misinformation. And so the existing federal framework, which is the Sports Agent Responsibility and Trust Act, and the state laws, which were adopted by more than 40 states, which is the UAAA, were designed for a traditional athlete-agent relationship that really contained a lot of blind spots when it comes to the NIL landscape. And what I mean by that is when you look at traditional agent representation, almost always you have some sort of players association involved. So let's take the NFL, for example. In order to represent a student athlete in their professional capacity, being recruited by teams in the NFL, you have to be registered with the NFLPA, the Players Association, right? No such Players Association exists at a college level because, as you all know here, there's no collective bargaining. Therefore, there is no status as an employer with their athlete and their institution. Therefore, you don't have a players association that really regulates and sets standards around, not only what the players bargain for, but what their representation looks like and what that representation can take. So where you have some of those guardrails in place with a players association, for college athletes, they don't have that regulatory framework, and the NCAA certainly does not provide it for agents, nor can they really extend their oversight to third-party agents, right? So they don't really have any pull or ability to regulate that group of individuals.
Before I let you and Sam, dare I say, nerd out on some of these sports law topics here for a minute, I want to turn it over to Joe. I want to give Joe a chance to chime in on a couple of questions or thoughts just on more layman terms that we try to bring to the scope here with this conversation. We've got a lot of administrators and parents and athletes who listen to the show, and that's more of what our target audience is. And so Joe can speak to that. What are the questions that you think make the most sense for someone in Olivia's shoes?
I mean, I've got a few. I mean, I think initially though, I mean, it's what are the horror stories, that have been out there? And I mean, I go back to the beginning of NIL, and there was a lot of stories. I can't corroborate any of them, but they permeated through the industry. I mean, there were agents that were signing kids to contracts, and it wasn't just about sports. It was they were signing over anything that they created for the rest of their lives in perpetuity.
Right.
You'd like to believe that those got weeded out pretty quickly, but then you hear stories of kids that they're signing with quote unquote agencies that are going to help them get placed at another institution, and they end up at institutions that weren't even on their list, but whatever they got from a rev share perspective, they're trying to get a percentage of this. And I mean, you're in it every single day. I'm somebody on the outside looking in, and I'm hearing stories. I'm kind of interested to hear some of, and I'm not asking you to bury anybody, just what have you guys been seeing that made this such an important next step for the state of Louisiana?
Yeah, so I'll speak to my prior experience with student athlete NIL, because we saw agents from all over the country that we engaged with. I'll give you one example. There are companies and agencies out there that will front money for student athletes, say, we'll pay out your deal right now in exchange for the exclusive licensing and use of your name, image, and likeness. And any money or any funds that come from any other third-party deal will have to be paid to us for use of your name, image, and likeness. So in that example, what they were saying is, hey, we'll make you a deal up front, right? We'll give you the $500K or the $1 million up front, and your contract will have essentially be paid out. But in terms of the go forward, in layman's terms, the use of the licensing of your name, image, and likeness, from now until forever, sometimes up to 10 years, we take a cut before you ever see that money. And so what would happen was we would try to engage a student athlete, and company would essentially approach us and say, we have the exclusive use and licensing of this student athlete's name, image, and likeness, and you actually owe us that fee. And oh, by the way, here's our contract that states that any fees paid to that athlete have to go to us first for us to take our cut, and then we'll distribute the money, which from an athlete perspective looks great up front, right? They do this a lot in the music industry with record labels and record deals. They pay that money up front, and then you have an exclusive use, right? However, when you talk about the volatility of being a college athlete for 4 to maybe 6, 7 years, right? Sam, I don't know all the details on eligibility, but let's assume you have 5 years. In college, you might be presented with any variety of marketing initiatives, from your local burger joint all the way through to regional and national brand partnerships. And that is entirely dependent on how you develop yourself as a brand. Now, maybe some of these companies are doing significant marketing development, but to preemptively sign an athlete at the beginning of their career and say, everything for the next 5 years is going to be owed to us first before you see a dollar, to me is predatory. And especially when you're talking about some of these major recruits in high school, you look at the lack of education and training that most kids have at a high school level and exposure to brand partnerships or advertising concepts in general. And it's easy for somebody in the business world without any regulation to step in and say, you know, I've done marketing before, or I've negotiated a real estate deal. I can certainly help you negotiate a rev share agreement, right? And so maybe it's not that they take it up front, but maybe it's that they charge 30, 40, 50% for a contract that, you know, in theory, that would be astronomical to charge by NFLPA standards, for example.
Mm-hmm. I mean, you said predatory. Now, those are going to be two of my follow-ups. I mean, you talked about, you know, 500,000 up front or $1 million up front. I mean, you hear stories of people that 5 to 10 grand is gonna be life-changing, and then they're signing kids, you know, for these crazy percentages. I guess, you know, for anybody in the college athletic space, you know, administrators are, I mean, they're up to their necks in alligators, and they're trying to get through this. I mean, for people that want to know how it works, you know, for something that's been collectively bargained, what does it look like, you know, in the NFL? What does a typical percentage look like for an agent contract? I mean, there's a difference between, you know, contract with the team and any sort of marketing agreement that you as an agent are going at and actually helping secure, which is where I think the agents are actually making, you know, the money on behalf of their clients. But I guess I don't want to say what should this look like. What does this look like at the professional level, so college athletics administrators can get a feel for, you know, what this is probably going to end up looking like at the college level.
Yeah, so what I will say is for any sport that does have a players association, and some of them don't, right? But for NFLPA, MLBPA, all of their rules and regulations are online and publicly accessible. So you can actually go and see what the rules are on agents. And I think overall, there is a gap in transparency, right? And so from a college athletics landscape, most administrators that I hear from are saying, well, we're hearing that so-and-so is taking X percent and this person is only doing X, Y, and Z, right? And so there's also a knowledge gap in what NIL representation actually is from a marketing perspective, right? How much you have to do as a marketing rep as opposed to a representative who is only negotiating a revenue share agreement. Both difficult, right? Difficult negotiations, but different as well. What I would say as an analogy is that the revenue share agreements look more like employment agreements at your NFL level. The marketing and the NIL side is really truly third-party brand deals and third-party marketing opportunities. And that's where you see a lot of the shortfall in understanding. Now, as far as what it should look like, if you go look at the Protect College Sports Act, it does put a percentage in there on specific types of deals. I am of the camp that, it is what the market calls for, and every agent is providing a different type of service to their athlete. So it's really hard to narrow down a particular percentage. It's really difficult, in fact, especially as things change every day, to understand what exactly these agents are representing their athletes for. So I think until we get a clearer vision of what the market is going to mature into, it's hard to put a particular number on it. I hope that's not dancing around your question, but there's a lot of confusion and a lot of misinformation here. And I think what everyone's trying to understand is, how do we ensure that agents are taking a fair, reasonable, and earned portion of what they are charging a student athlete?
Hey, I've learned, knowing Sam now for a while, that when you ask a question, a lot of times you're going to get, it depends.
and that's really right. But what I will say, and what we can go into, if I'm not jumping ahead, is kind of what we've done to close that regulatory gap in Louisiana, which is creating a regulatory framework that specifically caters to NIL agents. So it brings NIL agents under state oversight for the first time in their particular category. So we name professional agents by name and we name NIL agents by name, or endorsement representation, right? And so it requires all agents, whether you're representing for professional or NIL purposes, to register in Louisiana and actually have a preliminary level of training and a preliminary level of education and a background check that you have to pass. And which, by the way, most players associations require criminal background checks. So again, if we're talking about, some of the similarities between the two, this isn't out of the ordinary for your already established agents that are coming down from NFLPA and looking to represent college athletes for NIL deals earlier and earlier. So we've got the criminal background check, the mandatory training program, and that's developed in partnership with Advance NIL, who teaches financial literacy and agent education all over the country. We've got the preliminary application review, and then you've got to be registered through the portal before you can represent athletes in the state. So basically it means an agent can't simply say they're representing a student athlete in the state of Louisiana and start negotiating. There's actually a gatekeeping mechanism that's meant to at least ensure that agents know what questions to ask if they don't know the answers to some of the representation questions.
What in the state of Louisiana mean? Is that a Louisiana native? Is it at a Louisiana university? What does that mean?
Yeah, that's a great question, and it's one we get almost every day. So a Louisiana athlete means any athlete that is enrolled at a Louisiana institution. This is high school and college, right? It's not just college. Or a Louisiana athlete who is attending Ole Miss, for example. So you are covering the full gamut of athlete agents representing a Louisiana student athlete, right? And now if you have a California agent with a California athlete, they get recruited to a Louisiana institution. That registration process occurs when the student athlete is enrolled at the institution, for example.
I've got, like I said, I've got so many questions. I'll stop and let Sam go here in a minute. But one of the things you mentioned was 40 states, having, outlined, parameters for agents. With this new era, I mean, what are we needing to see happen to, what's on the books today versus what needs to be on the books to be current and modern?
Yeah, another great question. So for the 40 plus states that have enacted the Uniform Athlete Agent Act, one, there needs to be an adoption of the revised version. So what we've done in the state of Louisiana overall is we've adopted the revised Uniform Athlete Agent Act, but we've also given it teeth. And what I mean by teeth is there's a critical enforcement piece that was specific to our Attorney General and the initiatives that came out of the NIL group that studied it, which is student athletes need a direct right of action to sue their agents. So for decades, the Uniform Athlete Agent Act only allowed a university to sue if they were wronged in some way by an agent. So now in the state of Louisiana, student athletes have a direct right to sue agents for actual damages, attorney's fees, and forfeiture of any compensation to that agent. So essentially whatever percentage they took, they can get back. And then ultimately recover for any harm like eligibility consequences, finances, or reputation. And, previously, if an agent defrauded an athlete, the student athlete had limited recourse. It was usually contract law or tort law in some cases. But since now we have placed an enforcement directly in the hands of the injured party, which is the athletes themselves. And we've also made it an unfair and deceptive trade practice in the state of Louisiana so that the AG can also take enforcement action, meaning civil enforcement, not just criminal penalties like fines and 6 months in jail, right? So we have authority as the Attorney General's office to remove agents based on fraud, harm to the student athlete, harm to the school programs, or other violations within the statute. So it's kind of a double whammy here. Not only can you be sued by your athlete for anything that happens if you are unregistered or violate the law, but the Attorney General can also take action if a complaint is filed or if a student athlete files a complaint and say you actually are in violation of the law, which constitutes an unfair and deceptive trade practice.
Yeah, and that's all great to hear. Joe stole my questions because my questions were going to be, what is the difference between this new Louisiana framework and, the UAAA and the RUAAA and SPARTA, and also getting to is this, unlike SPARTA, actually going to be enforced? Because there's been so much criticism of SPARTA and kind of the federal frameworks and the fact that it's exclusively in the hands of the FTC, and the FTC, course of 25 years or so has not done a single thing about it. So definitely glad to hear, and really especially glad to hear that there's a private right of action there, because I know that's been a really, really major criticism of SPARTA.
Yeah. So the other thing, a couple of issues, I'll touch specifically on SPARTA, but we cover NIL agents. We also have direct student athlete remedies. We require background checks, which aren't currently mandated. And there's the preliminary level of training. And those modules touch on everything from financial literacy and understanding with your student athlete to the fiduciary duties of an agent to NIL. What is branding? What are brand partnerships? How do you get your athlete to understand what these NIL opportunities actually are? And then what are the differences between NIL and revenue sharing? Because that's extremely important for an agent to know as well. And then when you talk about enforcement in particular, the damages available were usually only to the schools and the FTC as far as SPARTA and the Uniform Act, whereas we have actual damages, attorney's fees, and compensation forfeiture that goes back to the athlete. So whatever percentage is taken goes back to the athlete. And then as far as the registration requirements, it's all agents, right? We've always regulated professional agents in the state. And now that we also regulate NIL agents, our registration has tripled since we've launched the program.
It's awesome to hear. And, another question I had is, you made the comparison to, kind of the registration schemes we see in player associations, and it's a really good comparison. One of the benefits to being able to have player associations and kind of through the collective bargaining agreement, to have that kind of agent regulation through that system is that through the CBA, teams are literally the NFL. They're literally precluded. They're barred from negotiating with non-registered agents. Is that something that Louisiana, through the framework, is that something that they can't even do, or is it something that they do? Where schools like LSU and CLU and all the different schools in Louisiana are actually barred from negotiating with unregistered agents?
Yeah, so here's what I will say. There's a grace period, but yes, generally. So if you are, it does not enforce it against the institution, but if you are negotiating a contract without being registered and we find out about it, we can prosecute, right? Now, how we would find out about that, it's usually a filing of a complaint. And we've got this robust complaint filing mechanism now to where you will fill out a complaint. It will actually cross-check with our agent registration system. It will ensure that that agent is registered. And then if they're not, that's a violation in itself, right? And they're holding themselves out to be an agent in the state of Louisiana. The other thing that I will say about involvement with third parties is under our law, we have essentially said that use of intermediaries is not allowed under the law. So the agent has a duty to act directly with the student athlete. So if there are other people involved, they are required to disclose that in writing to the athlete prior to them paying anybody else.
That's a really, really interesting point. That's a good point. I know, in a prior life, I worked as an attorney for an agent, and we used intermediaries all the time. We had, my boss, actually, the agent, very rarely actually met with the players. So, it's really interesting that you're, specifically targeting that very common kind of system where you have kind of runners, moving throughout and kind of being the ones who are really kind of interacting with the athlete on a daily basis.
Absolutely. And runners are quite different than what we would call the handler, right? There's this new trend in college athletics where you have the agent, maybe you have the marketing agent, and then you have a handler, right? Who takes a cut of everything. They're doing a lot of the negotiating, and whether it's a family member of a student athlete or it is an interested third party that the family trusts, right? If they're taking a percentage of the deal, that's going to have to be in writing. And we've actually instituted the same way that you have to give certain disclosures at a professional representation level. We have put into law that you have to disclose certain things about your endorsement representation in writing to them. And if that endorsement representation disclosure is not executed and we ask for it and it's not there, that's going to be a problem.
Awesome. I want to go back to your comment about fiduciary responsibility for an agent. And maybe if you could share a couple of examples of what that would look like in practice and what somebody who maybe hasn't been with someone who operated with the athletes or the client's best interest in mind, how could that look, and what should somebody be looking for if they're in a situation where they're not sure whether to know an agent is operating with their best interest in mind and upholding that fiduciary responsibility?
Yeah, so there's an enumerated list of duties and responsibilities that we have in the law currently. And that law, for anyone looking at it, is Senate Bill 389. And the enumerated duties within the law are not only to the athlete themselves, but also to the institution. So in some cases, the duty of an agent who is representing professionally for an athlete who is interested in negotiating professional deals owes a duty of notification to the institution, as well as certain duties to the athlete, right? And so when you look at it from both parties' perspectives, you are not only evaluating the duties that they have to the university anymore, which was the traditional mechanism, but you're evaluating those duties to deal fairly, to disclose everything that you are making and everything everyone else is making when you enter into a deal. And if you feel that you are not being treated fairly or that something is wrong, even if they are registered, you can still file a complaint. And that was extremely important to the Attorney General, was the mechanism to actually file a complaint and continue on with the investigation and that process, as opposed to, a statute that does some good but doesn't have any enforcement or teeth behind it.
Awesome. Well, this has been really enlightening. Really appreciated Olivia Nuss, Assistant Attorney General in Louisiana, for joining us on this. A few more questions for you, but want to know, you guys sound like you're so far ahead on a lot of these things, and a lot of these things sound like things that many other people should be clamoring for. How does someone in a different state potentially go about trying to raise this concern and raise this issue to where their home state could do something similar to what Louisiana was doing? What is the process for that?
That's a great question. So my first investigative strategy was to do the research. So maybe your state already has NIL agreements as a regulated type of agent representation, and maybe they're just not enforcing it or don't have the mechanisms or tools to do so. I've come across many states. We offer a kind of a type of reciprocity where if an agent is registered in a state where they have same or similar standards to ours, they can receive a discount and fee for an exchange of information from that state for their registration. Through that research, I have realized there are over 20 states that already have adopted the revised Uniform Athlete Agent Act, which has endorsement agreement representation as a type of regulated representation for agents. What I'm finding is it's either not enforced or there's no clear mechanism for reporting. And so what I would say to anyone who's interested in making a difference is, A, we can always be a resource. We're doing it in real time. But B, call the enforcement arm or the regulatory arm that is actually handling athlete agent registration and talk to them before seeking action with your representatives or senators, because it very well might be in place. And maybe it just needs the push to have somebody make it a little more robust than it currently is.
One of the things you keep talking about is you're actually able to put some teeth behind it. Like, what are the ramifications for somebody that's breaking this law? Like, if somebody's trying to represent somebody, or if somebody's taking advantage of another kid, what does the teeth look like?
Yeah. So basically, the AG's office is going to investigate the complaint. They can pursue civil actions, meaning fines and injunctions. They can pursue criminal violations. Criminal has always existed in the law. It's just when you talk about the actual effects of agents having penalties, it's more effective to have them give the fee back rather than send them to jail. But they can pursue criminal violations if it's egregious fraud, right? And then we can also administratively revoke the registration. So even before all of those things, we can do a revocation or a suspension of the license, and we would put the athletes that they represent on notice of that, right? So the AG, what's important to understand is the AG doesn't need a private litigant to act. So even if the athlete does not want to sue their own agent, we can initiate enforcement proactively. And then on the school side, on the institution side, tortious interference claims. You can pursue an unfair and deceptive trade practice claim by filing a complaint with us, right? it creates alignment to where the schools actually benefit from the enforcement tools as well. Things like damaged eligibility, reputational risk, all of those things are counted for here in this particular type of revised Uniform Athlete Agent Act that we've enacted. And then ultimately, the goal is deterrence, right? So economic deterrence, you don't want to forfeit your fees as an agent. Reputational deterrence, if we revoke your license or we suspend your license, the public registry that we display of registered agents in our state will likely contain some sort of star that says this person has been, suspended until they provide more information pending X. And then the legal exposure. So just the attorney's fees means the costs are real, right? So all of these things work together. And then the last thing that I'll say is the transparency piece. So in an effort to provide transparency around who is actually registered, we do maintain a public registry where athletes can go in and actually click on agents and confirm that the agent who's contacting them is registered. It's real, it's publicly available for anyone in the general public to see, which is in a lot of states, by the way. I think they're just hard to find. Perhaps most people aren't paying attention, but Sam knows as well as I do, you can go on most states' websites. I'll give you another example, Alabama. You can type in Alabama Athlete Agent Registration, and I guarantee you their public list will pop up as well. So a lot of it is education and outreach to the student athletes, their parents, and the institutions involved that these resources really do exist.
Sam, I want to know if you have any thoughts before we kind of get to the end of this conversation with Olivia. If you have any questions or comments on kind of where this thing is all headed and what she's been in charge of.
Yeah, I really do have one question. What would you say to someone who said, okay, well, this is the state of Louisiana passing this law. State of Louisiana is, Louisiana State, all these public institutions in Louisiana, they are part of the state of Louisiana. How is this not a conflict of interest? How do you respond to that?
That's an interesting theory. What I will say is just what I've learned from being in the AG's office for 6 months, coming from a private practice, is that we regulate registrations in many other sectors. So for example, fair housing, right? You have public entities that are involved with fair housing disputes. You have registrations that are needed in order to participate in certain areas of the market in virtually every market there is, right? So when you talk about licensing and registration, I would say about half and half. You'll see Secretary of State regulating some of those athlete agents, and then you'll see the AG's office regulating in the other half of states. In our state of Louisiana in particular, it's the AG's office. But the theory that athlete agent regulation comes from is the theory of being licensed to practice in a particular state. So in the same way that you see attorneys being licensed to practice in a particular state, right? Or you have to have a real estate license in order to be licensed to do real estate in a particular area. That is the underlying concept there. So as far as conflicts, I would say that the theory is more aligned with licensing and registration as opposed to any type of conflict with a public institution.
No, that makes a lot of sense. And, maybe it was a bit of an unfair question, but I know, just really kind of, again, I think there's a lot of people who kind of just say, okay, well, why can't the NCAA just regulate these agents?
Yeah, and it's a good question. And I think as far as why can't the NCAA do it, the NCAA is a private entity that relies on the membership of its institutions, right? And that the cooperation that they have with their institutions and with their athletes is what gives them the oversight. We are already seeing the NCAA being challenged by its own member institutions in some cases in court, right? And when you talk about regulating a third party that has not opted into following NCAA rules or regulations, it's even harder to regulate. So what happens at an NCAA level is they do not have the reach to be able to set any standards without being sued under any number of theories by this third party, right? So that is why state law right now is the controlling mechanism in order to set and establish standards that can actually be enforced.
I'm surprised they haven't done it yet then. Every other action they're taking is getting them sued right and left. So I'm surprised they haven't tried to do it.
Yeah, and I mean, Olivia, you gotta say the two favorite words of this podcast. It's violation of everybody. Antitrust law.
Right.
You go back to
but for your restriction.
What's that?
Right. But for your restriction.
Yeah.
That's yeah.
Yeah, and for those wondering why it would be antitrust law, I mean, you look at a theory like Collins v. NBPA, where you had an agent who got decertified. He sued the National Basketball Players Association for keeping him out of this market, based on kind of the collective action of all the different players. And the only reason it was able to survive is because of the statutory and non-statutory labor exemptions. And the states are blessed to not have to deal with antitrust violations, especially if it's just a single state. But yeah, no, for sure. The NCAA doing would be a massive antitrust problem.
Absolutely.
Well, Olivia, we appreciate everything. In the spirit of this show, unilateral decisions, we're not going to actually, this kind of removes the veil. We don't actually get to make unilateral decisions, which is why we get to play that part on the show. You do make unilateral decisions. You are in a position where that may be the case. We're not going to ask you to do that. However, in the spirit of the show, I'm curious, what's next on your list? You guys have put together the task force. You've identified what some of these things are that are coming down. And obviously everything changes every day right now. And you're seeing that as much as anybody. But you've got the agent registration in a really good place. What's something else on that list that will be coming soon that you think can help the industry at large?
Yeah, it's a great question. I think right now we're obviously watching the Protect College Sports Act. We're seeing how that evolves at a federal level. I think also it's a continued evaluation of the issues before us, right? So they started the NIL task force through Representative Young a year ago. Think about how much has changed in college athletics just in the past 2 weeks, right? I mean, Sam, Mike, Joe, you guys were talking about all the eligibility cases last week, and now we're on to athlete agent regulation, right? It's endless. And so going forward, what success looks like for Louisiana is a continued study and evaluation of how this space evolves. And that comes from everything from athlete agents to how the high school regulations are working and evolving to eligibility, all the way through to a study of women's sports, right? Because those issues are on the table as well. And so it will be up to our continued task force to decide what's next. And again, I don't unilaterally make that decision. That's a group effort, right? What are the things on the table right now that A, we can control, and B, we can make positive change with state law? And so those are the things that we're kind of evaluating moving forward over the next year.
Awesome. Well, thank you so much. Thank you for giving us the insight. Thank you for the work that you're doing to help keep things moving. We really appreciate you taking some time out and joining us this week on our episode of Unilateral Decisions. For Joe, for Sam, for Dom, who couldn't be with us, for everybody with ID 43 making this happen behind the scenes, Olivia, thank you so much. And to everybody out there, we'll talk to you next week.
Thanks, guys.